how a witness was retained. How a witness was retained is important to ask about. You want to know how they came to becoming an expert in that case. How did they come to be hired to do what they're going to do? Remember, I'm not talking about whether or not they went to a particular school. I'm talking about what were the facts, what came to be, what were the underlying circumstances that gave rise to them being retained. Were they called on the phone? Were they located through someone else? Was an email sent to them? Who contacted them? What was said to them about the case that would give them a reason to believe that they were the appropriate expert to handle that case? What specifically was said between them that would further support why retaining them for this expertise in this type of case was appropriate? You would want to question, therefore, not only whether or not they were retained by some sort of contractual document or some sort of oral agreement, but get into the specifics of what they actually did, how they actually came to connect with the person, the lawyer, the client who is hiring them. So, I might ask questions like, how did you first come to be retained in this case? I don't care what the answer, I want to know. And remembering our tools from questioning, when they say, I was called by a lawyer, okay, or if they say, I was sent an email, you might question them from their answer. Well, what made you or they believe that contacting you through an email transmission would be an appropriate way to make contact with you to inquire about your expertise? They may say something like, well, I've worked with this individual many times before, and this is the way they hire me. Well, you see, that's a great fact to learn, because later on, you're going to want to ask about what kind of relationship they have and whether that affects or biases them in any way. Whether they're more likely to testify favorably because they're making a lot of money or being, retained by them on a regular basis. That gives them a motive, a bias, some sort of reason why they might be more likely to help that person. So you can see that asking these questions in a baby step format is fundamentally important. How did you come to be retained? You indicated that you were contacted by phone call. Who called you? What did they say to you? What did you say to them? Then what did they say to you? Oh, they told you about the case? Yes. Tell me the specific words that you remember them saying to you that gave you the belief that you might be the right person to be an expert in this case. And whatever they say, remember, don't make assumptions. Well, he told me that this was a case that involved property damage, and it was damage to a house, and the house was destroyed by wind, and I was a wind engineer, and so that's what I learned. So that would give me a reason to believe I might want to be retained. Now, I don't assume that that's all they know. I might refrain or reframe that type of testimony by saying something like, okay, let me make sure I understand. You said that they told you that it involved a house or a building, and that the building was severely damaged by wind. Is that correct? Yes. Even though that's technically a leading question, I might be able to ask that question even over objection because I'm clarifying. It's like a predicate question to another question. The person says, yes. What else did they tell you? What else did Attorney Smith, did Client Major say to you? So by saying that, you see what I'm doing? I'm sort of making them say, well, there assumes that there's more information to give. They would have to say, they told me nothing else. So all that they told you was that a house was damaged by wind and you thought that was sufficient information for you to get involved? Yes. Okay, typically, what kind of information do you need, sir, in order to understand? Do you see what I'm doing? what I'm doing is I'm making sure I get an exhaustive amount of information every time I ask any line of questioning. I sometimes call it the exhaustion technique, but it's a technique that enables you to make sure you have all of the facts before you move on. Chances are the person will say, well, they didn't just tell me that. They also told me that the building was 12 years old. And they also told me that the building, was damaged by a lot of rain and water. And you let them finish. And then you say, is there anything else other than, and then you repeat what they say, other than the statement that there was a building, that it was X years old, that it was damaged by rain and wind, anything else? If they say yes, then you ask them what that information is. If they say no, I now have boxed them into the total amount of information. I might even say, is there anything else that I could show you or give to you or that you could review that would enable you to determine whether or not there were any more facts that were told to you? That witness might say no. Okay, then later on they can't testify that there were more facts. They might say, as a matter of fact, the lawyer sent me an email explaining all the facts. Wow. You see how I got more information? So you want to make sure that you're deliberate in the testimony that you're eliciting from them. So therefore you want to make sure that you are asking questions and not skipping over critical information. It's a baby step process. It's a very detailed and meticulous process because you really don't know what they're going to say. And chances are, if you take your time, you will get all of the information out of them. You will get much more information than you think by doing that. I want to ask them not only how they were retained, but what is the mechanism of their retention? What is your typical way that you are hired to become an expert? Oh, I have a contract that I send. I send a confirming email. I do it orally. I don't care what the witness says, so long as he or she says it. I want to find out what the base of their knowledge is. Okay, they say that. What's my next question? If they were to ask, well, it's a contract. Well, if I don't have that contract, I might say, where would I find a copy of that contract that you utilized in this particular case? They might say, well, I actually have a copy. Or you might have requested it in your notice because you did something called a subpoena ducis tecum, a subpoena that requests them to produce documents at that deposition. You might have gotten that through a discovery request long ago and now you have it. The concept is that I want to learn how they were retained because it might affect the way in which they testify. Is this the typical way in which you're retained? Or said another way, what is the typical way in which you as an expert are retained? Well, it depends, Mr. Major. Depends on whether or not I am hired for this expertise or that expertise. Or we use different contracts. Oh my God. Now I want to find out whether the contracts are different. Maybe this contract is a lower rate because he does more work for them. Maybe this contract is a higher rate because he doesn't do work for them, or because he wants to charge the opposite side more, or he wants to collect more. I don't know. But the concept is I want to learn. I want to find out the base of their knowledge. So I don't just say, how are you retained, and let's move on. The key to excellent depositions is to take your time, whether you're with an expert or not, and make sure you've exhausted an area so that when you walk out of that deposition, you feel comfortable that you have enough information. So I'm asking them, in the case of the retention component, how they were hired, the facts that surround how they were engaged. And I'm finding out what is their typical methodology, their typical way of doing it, so that I can determine whether this is different or similar. It may or may not have an impact on this case. But I don't want to not ask it and then find out later there was something that might have benefited me or harmed me. The concept through discovery and depositions is to learn what the other side says. I make the joke all the time, and you'll hear it throughout many of my lectures, that in depositions, I don't care what a witness says, so long as he says it. I don't care what a witness says, so long as she says it. What that means is I'm less concerned with what they say. What I'm concerned about is making sure I get everything they say out. And that whatever they say, that is something they're going to live with. They're making that bed that they're going to lie in. I'm going to understand exactly how to either approach that witness in the future, attack them in this deposition, challenge some basis for the way in which they're doing things, or some other methodology that's going to help me in this case. So when I'm finding out about the ways they're being retained, I can learn a lot. I can ask them not only how they were retained, how they bill, but what is the mechanism for charging? In other words, it says in your contract that you charge $250 or $950 an hour. When do you charge that rate? Or is there any other rate that you might charge that's different? I might ask those questions because oftentimes witnesses have different rates for what they maybe take in charge in depositions versus what they charge for reviewing documents versus what they charge for testifying at trial, or somebody may have a different charge for driving. So I want to learn that information so that I can understand how that might impact the case. I want to learn, therefore, not only how they came to be retained, what factual information was given to them that enabled them to understand that they were retained, that the documentation which formalized that, how that was communicated back and forth, what the terms of that agreement are, and then it may move me to other areas that involve how much they testified. It may involve their expertise in a particular area. They might be experts in different areas. And so I'm focusing in later on what kind of expertise is in this case. But I'm really learning here, how was the person retained? I'm learning, what were you retained to do? I was retained to evaluate the firearm used in this alleged crime and to determine whether or not the propellant, the actual bullet, was the same bullet that came out of this gun as opposed to coming out of another gun. I am a firearms expert. I'm a person I'm a ballistics expert. I'm a person who's going to look at matching up a bullet with its gun based on a certain type of formula. The way in which the bullet is shaped versus the way in which the interior of the gun creates that marking on that bullet when it exits. So I'm trying to learn what they are hired for. Sometimes their written agreement might tell you. Sometimes an email or a transmission might tell you. But the concept is to learn, well, let me see what you were hired to testify to. And I want to make sure that when I'm talking about retention, again, it's this box theory, this exhaustion technique of I want to make sure I have them in the box of whatever they're going to testify to, I'm going to know. You said you were retained as a firearms expert. Is there any other reason or any other expertise that you will be testifying to? Were you hired for any other reason other than as a firearms expert to evaluate whether this specific bullet was fired from this specific gun? I don't care whether he says yes or no, or she says yes or no. What I care about is the answer. Well, I was also hired to look at other bullets. Okay, well, I didn't know that. Let's exhaust that. Tell me what else you were hired for in addition to the examination of the bullet that was previously marked as plaintiff's exhibit number 2, or that will be marked, or the bullet in this case, or the only bullet, or however you're referencing it, to this particular gun. So the key is to understand what they're doing. They might tell you more information. Well, I was also asked to look at 3 other guns. I was also asked to look at the bullet. Here's what I want to make sure, expert, that I fully understand what you're testifying to. Are you testifying to anything else other than, and then you repeat what they said. That's why you would take good notes or type out good notes. Other than that this bullet was or was not fired from this gun, and that other guns do not match this bullet, or this bullet could not have been fired from other guns, and anything else. Or I might end it there and let them say yes or no. Okay, if they say no, then you know that those are the things they'll be testifying to, and they can't testify to anything else. You might even ask, if you wanted to, is there anything else that you have been asked to testify to? It's sort of a repetition, but if I'm not sure that they got the question correct or that they understood it, I might or might not ask it again. It depends. I might rephrase it, or I might take their answer at what they said, and then just later on, if they offer anything else, I might want to make sure that I go back and say, well, earlier on, this is what you told me you were going to testify to. Now you're testifying to something else. Let's go back and ask that question again. Sometimes when you have a court reporter present, you can ask that reporter to go back and find that. If you have something which they commonly call real time, where they plug into your laptop, and as they're typing, you're typing. In other words, you're seeing what is typed. It appears on your screen. Or if you have an assistant, that assistant is marking that section for you to come back to later, because it's important and critical that you understand what somebody's retained for, because that sets up the framework for what they're going to be allowed to testify to. So it is very important when you're engaging that. As you see, there are a number of questions you can ask when finding out whether somebody was retained, but you start to get to an understanding of making sure you understand what's in that box. What were they retained for? How were they retained? Is this the typical method? Have I exchanged enough questioning to understand everything that is necessary to evaluate what they're going to testify to in an expert witness capacity? That is an exceptional way and a good base for starting those questions. While there are many more questions we can discuss in other sessions, that should give you a framework upon which to build. One thing I might add about questioning with regard to their engagement is I want to know whether or not they were told exactly what that lawyer or client wanted them to find. What do I mean by that? Did they get retained to offer an opinion that the bullet came from the gun? Were they contacted and said, I want you to opine that the building structure, that is the envelope or the roof structure, was damaged by a hurricane and must be replaced because it cannot be repaired? Versus, I have a set of facts. It involves a building. I want you to evaluate this expert and tell me whether or not there's any damage. You see the difference in that questioning technique? I am learning whether or not they were sort of told to find a particular way, whether or not they were guided in any way, versus a more antiseptic approach of, hey, maybe you'll find against us, maybe you'll find for us. Those nuances can play an important role later on, but it is important to understand what is being told to them specifically as part of that retention. That builds on the earlier questions we had regarding how were they retained and what were they asked to do. Not just, I was asked to evaluate a firearm, but I want to drill down and find out whether or not they were asked to find a certain way. That subtlety can have a big impact later on.